You're watching Dad vs. CPS. Thanks for tuning in. And if you haven't subscribed to my channel yet, you better hit that bell because things are about to get real interesting. Okay guys, so I know a lot of y'all have heard of a man named Karl Lentz, right? And I just want to get some things clear with this video, right? And with his actual case, because we all know of Karl Lentz, and you know he's a pretty good talker, pretty good speaker. I mean, he talks pretty big game. I'm not gonna lie, right? So what I want to do is because I went onto his website, right, and he has some available documents from his case, but some of the stuff that's posted is blotted out, right, and it just seems like documents are missing, right? So I mean, granted, he did put his cause number on top, right? So we're going to go to Pacer, and we're going to just see exactly what happened in Karl Lentz's case. If he got his kids back or whatever it was that he was trying to do. Okay, so this is the document that David Jose more or less just plagiarized from Karl Lentz, right? So we're going to go ahead and just do a follow-up on Karl Lentz, right, to see what was the outcome of that, right? So we're going to go to Pacer. And we're going to search for Lentz, and we're going to put Karl, right? And then we're going to put search. Okay. Let's see. Well, let's go find parties. Okay, try it again then. Search. All right, here we go. Okay, so I'm gonna tell y'all right now that all of this right here, oops. Let's see. From this one right here, okay? This is the one that we're looking for because that is matching the same one that we have as right here. See how it says 00387, okay? So we're going to, and I've already been here before already, right? So we're going to click on it, okay? And we're going to put history of documents, okay? And we're going to put run query, okay? So here we go. This is all of Karl Lentz's files, 45, and that's a lot, right? So let's get started, okay? So obviously this one is not here for whatever reason why, but we're gonna start going through them all, okay? Let's just let's go for it, okay? So we're going to put download all. Actually, you know what? Yeah, let's do that. Okay, so that's gonna be 10 cents. You don't have to click both of these, okay? You just click one. Download documents. Okay. And let's see the first one. Okay, so this looks like a receipt. Okay. It's the main one. Okay, so that's the one. I have that one already. Okay. Let's go back to Chrome. That was 20 cents. Okay, so we got 20 cents already. Okay. So I already have both of these, so I'm going to go back. Okay, so now we're going to go on number 2, where it says order referring case to magistrate judge. Okay, and that's going to be 10 cents. So we're going to put view document. Okay. So Karl Lentz's name is Rudolfo. Rudolph Lentz. Okay. Order. It is hereby ordered that pursuant to 28 USC section 636 B1, This case is referred to the United States Magistrate Judge Wallace Capel Jr. for all pretrial proceedings and entry of any orders or recommendations as may be appropriate. Okay, so that's the judge, right? Mark E. Fuller. And that's that one. So we're going to download that one. Okay. Let's see. Okay. So let's go back. And back. And number 3. Notice. Okay, this one's going to cost 30 cents, guys. But, well, we're just doing research. This is a proof of service. Okay. In regards to proof of service, I, a man, now deliver upon the office of the court clerk for the federal court proof of service in that the Department of Human Resources has been duly served in my suit. I say here and will verify in open court that all herein be true. Thumbprint. And here's his summons and dismissal action. Okay, so this is you can get this off the federal court website. Here's the proof of service that he served his summons. Okay, so all these files will be in the description. So we're going to download this and we're going to save. Okay, let's continue. All right, number 3, notice. 30 cents. New document. Okay. Not sure why, but this looks like if it's the same document, but we're going to download it anyways. Okay. Inventory solution. 40 cents. I might have downloaded that one twice. My bad. Here we go. Okay, so it was blotted out. Wow. Okay, that's weird. I guess Karl Lentz actually just blotted it out in the beginning. Alright, I noticed on Tracer that you wish to alter my claim and convert it into a complaint. I believe this is going to cause an interference with my rights and confusion to all who will be reading my claim in the near future. If you are relying upon the law, I require of you to tender the Lentz Court your findings of facts and conclusions of law for your actions. Right, thumbprint. Here's just the cover sheet. You put diversity. Okay. Citizen of another state. That's what he put. And he put 360. Other personal injury. That's how he did. Private right of action. Jury demand. Forgery. Okay, guys. So I'm not saying that this is right. We're just studying what Karl Lentz did. We just want to see. So he's just putting Exhibit 29. The federal district courts are courts of records. Right. He's putting the character of courts. The federal district courts are court of record. Okay. I don't know where he's getting this from. Oh, okay. 25 Corpus Juris. Alright, that's where he's getting that from. Okay. Notice. I'm not sure why they blotted out. You gotta hate it that every time they scan your documents at the federal courthouse, right, or in most courthouses, everything just is black and white. But anyways, you know what? I didn't even download that one. Let me download it. Make sure we have it. Go back. we're going to go to the number 5, notice other. Okay, this one's going to cost me 40 cents, guys. Here we go. Notice, right to pursue a claim. I, a man, now require the office of the court clerk for federal court to not interfere with my right to pursue a claim. And he's citing some government website. If you are able to find an attorney to represent you, you have the right to pursue your claim in the court by appearing without representation. I say here, and will verify in open court, that all herein be true. Okay, so in note regarding notice right to pursue a claim. Right, so this is just like citing some other government website. Right, I guess right there, if you click on that, it'll say if you are unable to find an attorney to represent you, you have the right to pursue your claim in court by appearing without representation. Right, and all this and that. Okay. So remember, guys, this will all be in the link in the description, so that you can have these for study. Right, just to go back and research all this stuff. Okay, so let's download this one. Save and go back. Okay, go back. Alright, so we are at number 6. Report and recommendations. Alright, this one's going to be free. Awesome. Alright, so let's just go ahead and download this one right now, just so I can just get it over with. Okay, recommendation to the magistrate judge. Whoops. So this is going to be how many pages? 4 pages. Recommendation to the magistrate judge. Okay, so plaintiff filed his complaint on June 5th, 2013. Okay, document 1. On June 7th, 2013, the district judge entered an order, document 2, referring this matter to the undersigned magistrate judge. Right, for all pre-trial proceedings and entry of any orders or recommendations as may be appropriate. Upon review of the complaint, and for reasons that follow, the undersigned recommendations that this case be dismissed for lack of subject matter jurisdiction. Okay, it is settled that a federal court is obligated to inquire into subject matter jurisdiction, sua sponte, whenever it may be lacking. Hold on, guys. I'm trying to see who filed this. Let's go to the bottom really quick. Okay, all right. So this is the actual magistrate judge, right? I guess they're trying to dismiss it or something. But let's continue reading. Okay, upon review of the complaint and for reason, let me see. Plaintiff filed a claim. Upon review of the complaint and for reasons that follow, the undersigned recommends. So the judge is actually, because he's the undersigned, the judge, the magistrate judge, recommends that this case be dismissed for lack of subject matter jurisdiction. So already they are trying to dismiss Karl Lentz's suit, right? Okay, because it says that it is well settled that a federal court is obligated to inquire into subject matter jurisdiction, right? Sua sponte, whenever it may be lacking, right? And if the court finds that it does not have subject matter jurisdiction, the court's sole remaining act to dismiss the case for lack of jurisdiction. So there is going to be a case law cited, right? The judge is citing, and he cites another one too, because a federal court is powerless to act behind its statutory grant of subject matter jurisdiction. A court must zealously ensure that jurisdiction exists over a case, and should it itself raise the question of subject matter jurisdiction at any point in the litigation where a doubt of jurisdiction arises, right, and citing another case law, right, the court has undertaken such a sua sponte review and has determined the dismissal of this action necessary. Okay, so plaintiff has filed a pro se complaint in the case, referring himself as I, a man, prosecutor, against the Department of Human Resources. Right. Plaintiff claims that the wrongdoer trespassed on his property through a forged instrument. Wow. Right, which did and does cause harm and injury to his property. The trespass of August of 2001 and continues to at least the filing of this complaint. The plaintiff is seeking $371,520,000. Okay, the court first note that the court must first note that a review of plaintiff complaint reveals nothing about the plaintiff's claims. Right? That is, however, no matter for the court's analysis here. Plaintiff is attempting to file a suit against the state of Alabama, Department of Human Resources, DHR, or possibly a county DHR, which in either case are entitled to sovereign immunity with respect to all forms of relief asserted against them, and are due to be dismissed for lack of subject matter jurisdiction. Right? And the judge is just citing some case law there. Right? Several of them. Okay, several of them, right? So, accordingly, it is the recommendation of the undersigned magistrate judge that this case be dismissed for a lack of subject matter jurisdiction. Okay, so it is further ordered that on or before June 28th, 2013, the parties may file objections to the recommendation. Any objections filed must specifically identify the findings in the magistrate judge's recommendation to which a party objects. Frivolous, conclusive, or general objections will not be considered by the district. Okay, so in other words, don't be writing some bull crap. You know what I mean? So the parties are advised that this recommendation is not a final order of the court, and therefore is not appealable. Okay. Failure to file written objections to the proposed findings and advisements in the magistrate judge's recommendation shall bar the party from de novo determination by the district court and issues covered in recommendation, and shall bar the party from attacking on appeal factual findings in the recommendation accepted or adopted by the district court upon grounds of plaintiff error or manifest injustice. Okay, so then the judge just goes ahead and cites some more case law. Okay, and then adopting as binding precedent all the decisions of the former Fifth Circuit handed down prior to the close of business on September 30th, 1981. Very interesting. Done on this 14th day of June 2013. So this is the judge signing off, right? All right, and this document was titled recommendation. Okay, so I already downloaded that one, so we're gonna go back, and that one was free. Okay, so now we are on 7, a motion to dismiss. It says file entered and terminated. Okay, so this one's gonna cost 70 cents, guys, but you know, we're just trying to see truth. Okay, so this one's going to be 7 pages. Okay, and let's see who filed this one. Let's go scroll to the bottom real quick. Okay, so I undersigned. Okay. Okay, so this looks like this is coming from the attorneys of who he was suing, which would be the Alabama Department of Human Resources. Okay, the defendant. Okay, yeah. Okay. Oh yeah, of course, it's titled "Defendant's Motion to Dismiss." Okay, so the defendant that Karl was suing wrote this. Okay, come now, the Alabama Department of Human Resources, hereinafter defendant, by and through the undersigned counsel, and moves this honorable court pursuant Rule 12b-6 Federal Rules Civil Procedure to dismiss plaintiff's complaint in this action. Okay, defendant shows unto this court as follows: plaintiff's complaint. Okay, so on May 28th, 2013, you know what, guys? Let me download this before I forget. Okay, all right. So on May 28th, 2013, plaintiff Karl Lentz filed a lawsuit against the Alabama Department of Human Resources. Plaintiff served the Alabama Department of Human Resources. Okay, Plaintiff is seeking $371,520,000. That's a lot. Okay, Rule 12b6 standard. Under Rule 12b6 Federal Rules of Civil Procedure, dismissal of the complaint for failure to state a claim, failure to state a cause of action is appropriate when no construction of the factual allegations of the complaint will support the cause of action. And then the attorney is just citing case law, right? Where this is coming from also. So the court may dismiss the complaint only if it is clear that no relief could be granted under any set of facts in support of its claims. And then there is another case law. So it says the court recently stated the rule as follows. Okay, so this is actually Rule 12b6. Motion test the legal sufficiency of the complaint. Prior to the Supreme Court's recent decision in Bell Alt Corporation versus Twombly 127 CT. 1955, 2007. A motion to dismiss could only be granted if a plaintiff could prove no set of facts which would entitle him to relief. Okay, so more case law, and now in order to survive a motion to dismiss for failure to state a claim, the plaintiff must allege enough facts to state a claim to relief that is plausible on its face. Okay, so obviously you need to state a claim, right? And then you need to state your relief that can be granted. Okay, so while the factual allegations of complaint need not be detailed, a plaintiff must nevertheless provide the grounds, right, of his entitlement to relief. Okay, and a formulaic recitation of the elements of cause of action will not do. Okay, the plaintiff's factual allegations must be enough to raise a right to relief above a speculative level on the assumption that the allegations in the complaint are true. Okay, so it is not sufficient that the pleadings merely, leave open the possibility that the plaintiff might later establish some set of undisclosed facts to support recover. Okay, internal quotation and altercation omitted. In considering a defendant's motion to dismiss, a district court will accept as true all well-pleaded factual allegations and view them in a light most favorable to the plaintiff. And some case law right there, where a court is considering dismissal of complaint at the pleading stage, it must assume the allegations of the complaint are true. Oh, wow. Okay, but you have to put it into detail. You have to really work on your complaint, right? Even though it's just an allegation. All right. So, and then it says the court is not required to accept the plaintiff's legal conclusions, right? Nothing the tenant that a court must accept as true. All the allegations contained in the complaint is inapplicable to legal conclusions. Okay. So in evaluating the sufficiency of the plaintiff's pleadings, the court makes reasonable inferences in the plaintiff's favor, but is not required to the plaintiff's interference. Okay, and some more case law, right? Similarly, unwarranted deductions of fact in a complaint are not admitted as true for the purposes of testing the sufficiency of plaintiff's allegations. And some more case law stating conclusory allegations are not entitled to be assumed true. Okay, a pro se plaintiff is held to a less stringent standard than those of attorneys. Okay, so they're not too hard on pro se plaintiffs. Right? However, the court does not serve as de facto counsel for a pro se litigant. Okay, so there's case law to support that. In addition, the court cannot rewrite an otherwise deficient pleading in order to sustain an action. Okay, and then some more case law to support that. Right. Moreover, this court can only examine the four corners of the complaint, and some more case law to support that. Right. The plaintiff is required to specify the acts of each defendant which resulted in the alleged constitutional violation, and then there's some case law to support that. Right. So ordinarily, a party must be given, at least one opportunity to amend before dismissal of a complaint, and there's the case law to support that. However, right, the district court district court need not allow another amendment that would be futile and whereby the plaintiff has failed to correct the deficient complaint originally filed. And then there's some more case law to support that. If more carefully drafted complaint could not state a claim, then dismissal with prejudice is proper. Wow. So you gotta really be, stating exactly what's going on. Okay. So additionally, a court should not hesitate to dismiss a complaint when the plaintiff's allegation fails as a matter of law. Okay. Arguments. The complaint fails to state a claim. The Federal Rules of Civil Procedure require that a complaint contain a short and plain statement of the claim that will give the defendants fair notice of what the plaintiff's claim is and the ground upon which it rests. Okay, and then there's some case law to support that. Even under the notice rules of pleading, the complaint must state a cause of action in sufficiency to affirmatively show the plaintiffs are entitled to relief for, and then it goes on to quote something, right? It is not enough to indicate merely that the plaintiff has a grievance, but sufficient detail must be given so that the defendant and the court can obtain a fair idea of what the plaintiff is complaining, okay, and can see that there is some legal basis for recovery. Okay, so here's some case law to support that. Okay, no, actually, that's coming from something. Moore's Federal Practice, Section 8.13, Second Edition, 1984. Okay, and it's gonna go on to, I guess it's just in. That's a case law right there. I know that in Ashcroft versus Equable, whatever, however you say that, the Supreme Court reiterated that although Rule 8 of the Federal Rules of Civil Procedure does not require detailed factual allegations, it does demand more than an unadorned, the defendant unlawfully harm me accusation. Okay. Oh wow. Okay, so you can't just say that you can't just be simple, like the way Karl Lentz says, right? A complaint must state a plausible claim for relief, and a claim has facial plausibility when the plaintiff pleads factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. The mere possibility the defendant acted unlawfully is insufficient to survive a motion to dismiss. Okay, so the well-pled allegations must nudge the claim across the line from conceivable to plausible. Okay, and then there's some case law to support that. Unsupported conclusions of law or mixed fact and law have long been recognized not to prevent a Rule 12b-6 dismissal. And then there's some more case law on that, okay? And the complaint in this case contains many conclusory allegations, but even considered in gross, the conclusions of the plaintiff support no claim against the defendants. Okay, so plaintiff's claims are barred against the Alabama Department of Human Resources. Okay, the plaintiff named the Department of Human Resources as a defendant in this civil action. The Department of Human Resources was created as a state agency by statutory authority. See Alabama Code, Section 38-2-1, 1975. Where a party attempts to sue a state agency in federal court, the 11th Amendment prohibits the federal court from exercising jurisdiction over the suit, except where the state has consented to be sued or waived its immunity, or where Congress has overridden the state's immunity. And there's some case law to support that. Okay. In this case, the Alabama Department of Human Resources has not consented nor waived immunity. Okay, so this is the plaintiff's trespass claims are time barred. So the plaintiff's claims for trespass are property in time bar. Okay, so plaintiff alleges a trespass of property commencing on August 14th, 2011, those claims are barred by the expiration of the applicable 6-year statute of limitations provided by Section 6234, Code of Alabama, 1975. Wherefore, these above premises considered defendant Alabama Department of Human Resources requests this court dismiss plaintiff's complaint with prejudice in each and every count against the defendant and grant such further and different relief as this court may deem proper. Respectfully submitted this 17th day of June 2013. And this is going to be the Assistant Attorney General, right, for the department, for the defendant named Alabama Department of Human Resources. Okay, so there's that documented file. There's the certificate of service. The undersigned, hereby certify a true copy of the above and foregoing was filed via the CM/ECF system, and a copy of the same mailed to the plaintiff via U.S. mail postage prepaid on this 17th day of June 2013. And then that's, I guess, his Karl Lentz's address. So I'm going to go back. Okay, so now we are on number 8, and this is going to be a notice. So it's going to be 20 cents. Okay, and I'm going to try to remember just to download them as soon as I open it up. Okay. So this seems to be like an order that Karl Lentz, man prosecutor, right, is doing, right, obviously. So the Lentz court requires a magistrate, right. This is coming from Title 28 U.S.C., which means United States Code, Section 636B1. It's come to the attention of said court that services of Wallace Capel Jr., magistrate, are available to serve said court. If Wallace Capel Jr. believes he is qualified to minister the affairs of the court, his honorable services will please said court. Okay, so and this is Karl Lentz proving that he has served Debbie, the court clerk. Okay, so let's go back. That was 20 cents. Alright, so we're on number 9. Okay, this one's going to cost 20 cents. Okay, so I'm going to download it. Alright, so then this one's going to be 2 pages. This is a notice. This is Karl Lentz's work, because I am man prosecutor. Okay, notice. The Lentz court delivers notice. I, a man, declare any interference of, for, or with the enjoyment of my property, the exercise of my rights by any qualified employee of court will be held liable for damages due to injury and or harm resulting from and arising out of any tortuous act, error, or omission of the individual trespass upon the case. I will require compensation of $1 for every second moment in time for any trespass. And just let's thumbprint again, and then this is being mailed to Debbie, the court clerk. Okay, so let's go back. 20 cents. Okay, guys, we are on number 10, but how many was there? 45. Okay. It's gonna be a long video, guys. Okay, new document. Alright, this is another notice. Let's download this right now. Okay, so I, a man, declare the Department of Human Resources hereinafter DHR and its commissioner are interchangeable. The man known as Ira Dement did also hold this belief by his actions as a senior judge. Memorandum, opinion, and order, Ira Dement, senior district judge. The commissioner of the Alabama Department of Human Resources, DHR, is the defendant because a lawsuit against a public official in its official capacity is in effect a suit against the underlying public entity. The court refers to defendant and DHR interchangeable. And then he's citing some case law too. Okay, this is a copy. Let's go back. Okay, so we're going to go to number 11. Alright, so this is 10 cents. Okay, and we're going to download it. Okay, so let's read it. This is one page. This is a notice. The Lentz court delivers notice. I, a man, declare for the first approximately 6 years of the wrong, then he's putting the time between 2001 and 2007. The Department of Human Resources, hereinafter DHR, was under the control of a consent decree, RC consent decree of 1991. DHR was under the control of the United States. The District Court for Middle Alabama, hereinafter ALMD. The ALMD was under the control of William Harold Alberton, 3, Chief Judge. Mark Fuller, Chief Judge. Alright, so the man known as Mark Fuller has been assigned by the Office of the Clerk, or the Court Clerk, into a position of presider within my case. Okay, so this is just a notice. Okay, so let's go back. Okay, we're on number 12. This is a notice. This was 10 cents. Okay, so this is notice. The Lentz court provides notice. Firstly, I, a man, enter my case. Suit accruements into federal court. Secondly, federal court is to convene at a public courthouse venue. Thirdly, the public courthouse is where my case lies, is known as a federal district court. Fourthly, the federal district court is at a location also referred to as the Frank M. Johnson Complex, the United States District Court for Middle Alabama, Northern Division, the District Court of the United States. Fifthly, the name of the public courthouse varies, but the name of the public courthouse varies, but at all times my case lies in federal court. I say here, and will verify in open court that all herein be true. Signed Karl Lentz, thumbprint, and this is mailed to Debbie, the court clerk. Okay. I honestly don't know why he's mailing these things to the court clerk, because she's not even party to this case. Because I'm not even sure if he's even sending, because whatever you file, you have to send to the other side, which would be the state of Alabama. But for whatever reason why he's mailing this to the court clerk baffles me. But anyways, okay, so number 13. This is going to cost 10 cents. Alright, notice, jurisdiction. Okay, because you're supposed to cite the jurisdiction, right? Okay, so the Lentz court presents notice. I don't know why that's looks covered, but whatever. Might be he put white out and then he put a line through it. I don't know, but it says my case suit. It's a pretty tough word. I'm not gonna lie. Accoutrements, right? Whatever. In federal court. Secondly, I pay money into a federal court. Okay. A party paying money into the court admits the jurisdiction of such court and cannot plead in abatement to it. And then there's something J Shitty page 444-1851. Okay. So thirdly, federal court is a court of record. Okay, 25 CJ volume federal court section 344 page 974. Okay, so CJ means corpus juris. Right? So fourthly, in a court of record, the magistrate is independent of the tribunal, and he's citing Black's Law Dictionary, 4th edition, page 1014. But what he really should do is he should be actually citing the actual case law that goes with it. Okay, but because he's just citing Black's Law. Okay, so fifthly, a court of record acts in accordance with the common law. and he's citing the Black Law Dictionary, 4th edition, page 1014. And although it might come from that page, he should cite the case law. Right? Sixthly, suits in common law, the right of the trial by jury shall be preserved. Okay, so that does come from the Bill of Rights, obviously. Okay, so 7thly, the jury can take upon themselves and determine at their own hazard the questions of fact and law. Okay, CF Littleton, section 366, Blackstone's commentary, section 378. Okay, so that's where that's coming from, Blackstone's commentary. So eighthly, I say here and will verify in open court that all herein be true. Okay, let's go back, and we are at 14. Okay, so new document, and we are going to download this right now. Save. Okay. So, this is going to be notice for signatures. The Lentz Court presents notice. I, a man, declare and require all documents, including recommendations and orders, being placed into the case file to have affixed upon it wet ink, blue ink, signature of its creator, no rubber stamps. All documents submitted without wet ink, blue ink, signature, the court will take notice as a contempt of court and will be void. Secondly, I say here and will verify in open court that all herein be true. Now, I honestly don't think that the court's actually going to acknowledge any of that, because I'm just telling the court what to do just because you say. I really don't think what he's doing is even correct. You can't just tell the court what to do. 15. Right, 10. This is 10 cents, guys. And download. Right, first thing I want to do is download it. Alright. Notice verifications. This is Karl Lentz again. Okay, the Lentz Court presents I, a man, declare and require all documents, including recommendations and orders, being placed into the case are to be verified in open court under oath and or affirmation. All documents submitted without verification will take notice as a contempt of court and be void. He's just telling the court what to do. That's, to me, honestly, that's nonsense, really, because it's actually the judge that makes the decision. Right. So, secondly, I say here and will verify in open court that all herein be true. Right. So that's just that one. All right. So that was 10 cents. Let's go back. Alright, so we are at number 16. There's another notice. 10 cents. Alrighty. Let's see. Document 16. This is Karl Lentz 2. Alright, so notice timestamp documents. And it looks like something is just like blotted out right there on top. You see that? It's weird. Okay. Firstly, I, a man, declare that all documents filed to the office of the court clerk must be timestamped. I require all documents, including recommendations and orders, being placed into a case file to have affixed upon it wet ink, blue ink signature of its creator, no rubber stamps. Okay, so all documents submitted without wet ink, blue ink signature, court will take notice as contempt of court and be void. Thirdly, I require all documents, including recommendations and orders, being placed into a case are to be verified in open court under oath or affirmation. All documents submitted without verification, court will take notice as a contempt of court and will be void. Okay, so fourthly, I say here and will verify in open court that all herein be true. And let's scan it, see. Go back. Number 17. Notice. It's going to cost 20 cents. And let's download. Save. So this one's coming from Karl Lentz too, prosecutor, obviously. Order. Okay. So Department of Human Resources, hereinafter DHR, answers document 7. DHR admits to the wrong 12b6, but believes there are loopholes, technicalities in which DHR hopes to avoid paying compensation for the wrong. Henceforth, the only duties of the referral or presider are 1. To act as an impartial third-party witness, independent of the tribunal. 2. To maintain court decorum during the trial by jury. 3. To bear witness for the court clerk of the verdict of the jury. So I claim it is necessary and proper for my case to stay its course, for I present my case in a public venue by way of a trial by jury. The public at large needs to be made aware of the wrongdoers amongst them for DHR. Okay. So to have due process before a trial by jury, to testify in open court under oath and affirmation in order for DHR to present the merits of the loopholes before a trial by jury until DHR tenders compensation for damages. Okay, and then it's just, I'm not sure why his signature's whited out, but well, yes. Alright, so I guess this is a proof of service. Right. Okay, so let's go back. Oops. Okay, 18. This is 20 cents. And this is document 18. Okay, so this is going to be Karl Lentz again. I am an prosecutor. This is a notice for the pacer. The Lentz court presents notice. I notice a case filed a few moments after my case. See Exhibit 44, stylized by the court clerk as jurisdiction. Okay, and 28:1332 diversity, breach of contract, nature of suit. 190 contract other, cause of action, diversity, breach of contract. I have required the court clerk to stylize my case. See document 4, page 2, as a claim upon pacer. As jurisdiction 28:1332 diversity, nature of suit. 360 personal injury, other. So what he's referring to, guys, okay, this is on the actual civil cover sheet for whenever you go file a federal lawsuit. Okay, that's what those codes are. 360 and diversity, forgery. Okay, so to date, June 24, 2013, the court clerk converted my case into a complaint, as pacer reads. And I actually want to tell you, okay, that I've actually looked up the Federal Rules of Civil Procedure, okay, and it actually says, right, in the rules, okay, and I want to say it's Rule 3, that a commencement, right, of a lawsuit is done with a complaint, right? So, I mean, there's no way around it. You have to file a complaint. You do, right? Okay, so we are at, I required the court clerk numerous times, see document 4, to give her findings of facts and conclusion in law as to how making such utterance false upon pacer would be benefit of, for, or to the public at large. Right, those to the Lentz court. I, a man prosecutor, B, the defendant, C, the referral, D, presider, E, the court clerk. To date, the court clerk has failed to explain her facts. We don't think that the court clerk is even obligated to answer any of this. I mean, you know, you gotta admire his ambition. You really do, right? So, let me see. So right here, I guess this right here is the actual system of pacer back then, right? Obviously, because he just took a screenshot or printed it, right? Sniped it or something. Okay, that was 20 cents. 19. This is 10 cents. And this is Karl Lentz again. So this is notice. Agents of federal government. Right? The Lentz Court presents Department of Human Resources. Herein, DHR is an agent of the federal government. And he's going to go ahead and cite some statutory code. That's what it looks like. The Code of Alabama, right? 1975. Section 38-2-6 5 DHR. Duties, powers, and responsibilities of the State Department. Act as the agent to the federal government in willful matters of mutual concern and in the administration of any federal funds granted to the state to aid in the furtherance of any functions to the State Department. It's cut off right there. Being empowered to meet such federal standards as they may be established for the administration of such funds. Secondly, there appears to be a conflict of interest as Wallace Capel Jr. At times acts as a federal agent. I want to say that as a judge that he's referring to. Okay. I am not competent in legalese. Within a legalese letter sent to me by Wallace Capel Jr., a referral, he believes the United States District Court for Middle Alabama, Northern Division, herein a ALMD has no jurisdiction over any other federal agent. Fourthly, Wallace Capel Jr. Must not have noticed that the ALMD had jurisdiction of DHR for 18 years. Its control over DHR has just ended as of January 16, 2007. CRC Consent Decree of 1991. Fifthly, it is the belief of others, right, of the ALMD that it has no jurisdiction over DHR. Fortunately for I, a man, I have the inherent capacity, power, right, authority to summon any wrongdoer, federal agents into a court of record, and have whomever tried before a trial by jury. Okay, so interesting. Okay, so how many was there? It's gonna be 45. Okay, so on 37, obviously something happened there. Okay, so we're on 20. And this is 10 cents. So this is notice, latches, verified, right? This is Karl Lentz's document too. So here we go. The Lentz Court presents notice. Firstly, I, a man, declare as a man. I am not bound by legalese, latches. And what is he citing? He's citing no latches can be imputed to the public. For Mass Rep 522. I'm not sure where this is coming from. Dan's App Index. Okay. Alright, secondly, it appears to the court that the attorney for DHR is unaware that It appears to the court that the attorney for DHR is unaware that as when I was made known as to how the wrong I claim was committed did not occur until July 2nd, 2009, well within his Alabama statute of limitations. That was a very hard sentence to read, considering the way it was written. Anyways, so thirdly, I do not converse into legalese, nor is there a law which claims I must, in order to pursue a claim through this public venue. Okay, so fourthly, I say here and will verify in open court that all here in be true. Okay. Alright guys, and if I forgot to download them, I'm going to double check, and I'll just throw them in later, do the drive folder. But just remember guys, all these files will be available on the drive for your study and enjoyment. Okay, so I just got to keep remembering to download it. Okay, so this is one page. Okay, so notice, this is Karl Lentz 2. Notice, nature of party. The Lentz Court presents notice, right? Firstly, I declare that the nature of the party who presents his case before the court is a man. Okay, secondly, I say here and will verify in open court that all herein be true. Okay, that was 10 cents. And we are at 22. This is 10 cents. And let's download. Say, I, the man, prosecutor. This is Karl Lentz again. Notice timestamp. Okay. The Lentz court presents notice. Firstly, okay. The notice is to aid and protect the court clerk from any claim or injury or harm due to arising from tortious acts, errors, or omissions while in the performance of such individual duties as an officer of said court in regards to timestamp. Secondly, I, a man, require the court clerk that the instant of presentment of any and all documents, articles, said clerk must affix the proper timestamp. Thirdly, the court clerk forgot to fix a timestamp upon articles. I will forgive those of their trespass on the case, as I wish forgiveness of those upon whom I trespass, right, upon the condition that they offer a cure or remedy the wrong. Fourthly, I say here and will verify in open court that all herein be true. Okay. Let's go back. $23. 10 cents. Okay, let's download. This is Karl Lentz again. This is Notice Magistrate. Okay, the Lentz court presents notice. Firstly, I, a man, declare in and on behalf of the Lentz court in this instant case, it is necessary and proper that a person be summoned into the office of magistrate. Secondly, a magistrate is to be independent of the tribunal, fair and just, a third party impartial witness to tender back to the court clerk the verdict of jury. Thirdly, on June 12, 2013, I made my wish known that if Wallace Capel Jr., a man, believes he is qualified to minister the affairs as a magistrate for a court of record, his services would please said court to date the man fails to tender an answer. He's talking about the judge. So fourthly, I took notice on Pacer that a man, a presider, Mark Fuller, right, the other judge, has assigned Wallace Capel Jr. to magistrate the affairs of a case, okay, in the United States District Court for Middle Alabama. If he is predisposed within that case, please advise as to whom within the office of the court clerk is available to attend the Lentz court. I say here and will verify in open court that all herein be true. Okay, so let's go back. That was 10 cents. Alright. We're almost done, guys. 24. 10 cents. One page. So this is a notice. This is Karl Lentz again. Characteristics of a party. Claimant. I. Plaintiff. Right. The Lentz court presents notice. Firstly, I declare that a characteristic of the man who moves his court in my case, which contains my claim through this venue, that is that of a claimant and not of a plaintiff. But you have to be a plaintiff. Okay. Oh my God. Let's see. Secondly, any document filed into my case with the word plaintiff affixed, court is to take notice of the wrongful conversion and see the word as claimant. Alright. Thirdly, any further references to I, a man, the claimant, as being referred to as plaintiff, court is to take notice as contempt of court. So right now, at this point, he's just getting very frustrated and very upset. The fact that they keep calling him a plaintiff and not a claimant. Okay. All right. Claim. A claim is a challenge of ownership of a thing which a man has not in possession and is wrongfully withheld by another. Okay, so he gives a reference to that. 1. To demand by or as by virtue of a right, demand as a right or as due, to claim an estate or inheritance. 2. To assert and demand recognition of a right, title, possession, etc. Assert one's right to claim payment for services. Claimant, okay. I wonder if that means noun. So a person who claims, okay, so he's given a definition. Okay, so these are definitions, right? A claim. He's given the definition for claim. Now it is his definition for claimant, right? A person who claims, one who demands anything as his right. 2. A person who has a right to claim or demand. Alright, so plaintiff, 1400. I guess he's given the definition to a plaintiff, 1400 from Algo FR. He spelled it weird. I guess that's an older way to spell it. Anyways, noun use of OF, plaintiff, complaining, wretched, miserable, from plainte, right? See plaint, identical in plaintive. At first, the form that receded to legal usage retained the older if spelling. So he literally just broke down plaintiff. That's pretty awesome. All right. Fourthly, I say here, and will verify in open court, that all herein be true. Okay, so that was 10 cents. That's a lot of notices. Like, seriously. Okay, so 25. 10 cents. Notice jurisdiction. This is Karl Lentz again. Alright, firstly, okay, the Lentz court presents notice. Firstly, I, a man, declare the nature of the parties are diverse. Nature of prosecutor, man, and then he's putting Title 28 U.S.C. Section 1332. Secondly, I say here and will verify in open court that all herein be true. Okay, so let's see that. Go back. Okay, so we are on 26. Okay, so this is one page. Okay, so this is Karl Lentz again. Okay, he's filing this. Again, he's I, a man, prosecutor. Notice characteristic of party, claimant, plaintiff. Alright, so the Lentz court presents notice. Firstly, I declare that a characteristic of the man who moves his court. I want to say that we just saw this one already. Okay, so I'm going to file the same thing again. Okay, so we're going to skip that. Okay, 27. Document. This is 10 cents. Okay, let's download it. Save. Again, guys, if I accidentally did not download these right now, eventually when I put them in order, I will go ahead and organize it, and I'll see the ones I'm missing, and I'll just come back and download it again. Okay, so this is Karl Lentz again, and this is his notice for jurisdiction, and he's putting Saver Suitor, supplemental to notice jurisdiction, June 19, 2013. Okay, so the Lentz court presents notice. Okay, firstly, I, a man, as suitor, will choose the manner in which I present my case to the jury. And he's putting U.S. Constitution Amendment. Okay, so secondly, no man nor person within this courthouse has the capacity to interfere amend, alter, modify, interpret, deny my claim prior to a verdict tendered from a jury. Okay, so that's coming from Littleton, Section 386. That's Blackstone's commentary. That's Section 378. Thirdly, I declared the right to, of, and or for a trial by jury. And then U.S. Constitution, Amendment 7. So I say here and will verify in open court that here and be true. Okay. $28. View document. Just 10 cents. Just download it. Save. Okay, so this is a notice. Sovereign. Okay. Interesting. This is Karl Lentz again. The Lentz Court presents notice. Firstly, I declare that if Department of Human Resources, hereinafter DHR, claims to possess power of that of sovereign, a god, such a claim would be frivolous. For DHR is a bound person. Secondly, DHR is bound by laws, rules, regulations, ordinances, consent decrees, statutes, codes, policies. And I want to say policies is spelled wrong. I'm pretty sure that he did. Anyways, thirdly, sovereign is a perfect example of a ward in which a religious cult, a government, or legal society takes for itself a ward found amongst the common parlance, sovereign, and converts / perverts it into a term of art in order to afford itself godlike status and to shield it from claims of wrong made woman right, or man in which it serves. Right. Then he's gonna go ahead and I guess bring something up from Webster's dictionary, probably most likely from 1828. Dr. Webster says, or this is just coming from Dr. Webster, I guess. We retain this barbarous orthography from the Norman Sovereign, right? I wonder if he's accidentally spelling that wrong, or actually reading it, or putting it the way he wants. I don't know. So the true spelling would be the barbarous orthography from the Norman Sovereign. The true spelling would be from sovereign, from the, and it's cut off at the bottom, so it's kind of hard to sovereign, comparative. All right. I'm not sure where he's going with this, but whatever. So, fourthly, note well that a man known as Ira Dement, a judge, your colleague of this federal court on July 19th, 1989. I honestly don't know what the heck he's doing here. I really don't. In a private right of action, determined that the DHR lacks qualified immunity, a much lesser degree of immunity than sovereign. He also ruled the DHR on its 11th Amendment status. I guess he's talking about the judge, right? I say here and will verify in open court that all here and be true. Okay. That was 10 cents. Okay, so this is 10 cents. This one. It's another notice. Let's download it. Save. Alright, this is Karl Lentz again, filing another notice. Notice characteristic of party, prosecutor, / pro se. Okay, so the Lentz court presents notice. Okay, guys, I want to tell you right now, okay, you have to be pro se if you want to be without an attorney. That's just the way it is. Okay, so firstly, I declare that a characteristic of the man who moves his court, in my case, through this venue, is that of a prosecutor, and not of pro se. Okay. So secondly, right, any document filed into my case with the word pro se affixed, court is to take notice of the wrongful conversion and see the word as prosecutor. Okay, so he's trying to tell the court what to do. Right. So thirdly, any further reference to I, a man, the prosecutor, as being referred that thing stylized as a pro se, court is to take notice, contempt of court. Again, he's trying to tell the court what to do, right? So, prosecutor, noun. Now he's giving the definition: one who pursues or carries on any purpose, plan, or business. Fourthly, I say here and will verify in open court that all herein be true. So, okay, that was 10 cents. Oops, 30. Almost done, guys. This was 10 cents. And let's download it before we forget. So this is notice a characteristic of party, common parlance, legalese. So this is Karl Lentz again filing this. Okay. So the Lentz court presents notice. Firstly, I have been receiving letters in my mailbox, and it appears a man, Larry Lynn, and a man, Wallace Capel Jr., that's the judge, right, are attempting to communicate to I, a man, in a language foreign to me. I believe it's called legalese, right? Examples. 1. A pro se is held to a less stringent standard than those of attorneys. Okay. 2. Dismissal of the complaint for failure to state a cause of action is appropriate when no construction of the factual allegations of the complaint will support the cause of action. So he's talking about that recommendation thing, right? That the judge had sent him, right? I guess he just got mad at that, right? Now he's referencing it. Okay. So secondly, I do not have to attempt to decipher such incantations, for my case lies in federal court, a court record, which converses in the words found amongst the common parlance. Thirdly, I do not converse in legalese, nor Chinese, Nipponese, Spanglish. That's funny. Fourthly, there is no law in which I subscribe to which compels me to accept, translate, decipher, or make use my limited and valuable resources upon documents tendered in legalese. Okay, so I do not lower my status to that of an attorney. Okay, for I will stand in open court and affirm all I said within written word, and all I will say via vos, right, is true, and attorney will not. Okay, so by the shows and actions of Larry and Wallace, right, proves it is necessary and proper for a trial by jury to commence post haste. Seventhly, I say herein and will verify in open court that all herein be true. Okay, so let's go back. We are at 31. 10 cents. This is Karl Lentz again, guys. Okay, so it's going to be notice, party, real. The Lentz court presents notice. Firstly, I, a man, declare my claim is against the wrongdoers, who throughout the years has referred to herself as Department of Human Resources here in DHR. Secondly, a man known as Larry Lynn claims to be counsel for Alabama Department of Human Resources. Thirdly, in my case, I claim DHR is the wrongdoers. Fourthly, at this time, the court does not notice the interloper, A, Alabama Department of Human Resources, as the same person as DHR. Court will accept that DHR commences in other names, titles upon proof of claim. Sixthly, I say here and will verify in open court that all herein be true. Okay. Again, guys, if I forgot to download it, don't worry, because because I'll find out when I put them in order as I start numbering them in the drive, and I'll know which ones I forgot to download, if I did. I hope I don't, though. I'm trying to download them as soon as I open them. Okay, this is one page. This is Karl Lentz again. I am man prosecutor. He's still calling them wrongdoers. So there's a notice, real party. Okay, and I want to say that that's going to be very hard to. Well, I'll read the first one because I can't read the other ones. I don't know what they say. So, firstly, I, a man, declare a man, Larry Lynn, claims to be counsel for Alabama Department of Human Resources, hereinafter DHR, and he requests to dismiss my case. Okay, so I can't read that, so we're just going to go back. Oops. Go back. Okay, so we are at 33. This was 10 cents. Okay, so this is Karl Lentz again. This is a notice. This is a notice characteristic of a party. Okay, I want to say that I've read this one already. I'm pretty sure I did. Okay, so. It was 10 cents. Okay, so this is Karl Lentz again. I, a man, prosecutor, Department of Human Resources, wrongdoers. Okay, this is a notice. Notice. Court. I'm not sure what that's about. The Lentz Court presents notice. Firstly, Department of Human Resources here in DHR. DHR wrote me that I should pursue the DHR into a court of law, not into a court of equity. Code pleading a federal rule civil procedure, right? So I guess this is somebody that emailed him from Long James E. DHR. James, I guess somebody, right? Okay, so reason for failure to respond. So DHR does not believe that you have a claim. DHR will not be paying you any money or giving you other relief. If you feel you have a claim, you should feel free to pursue your claim in a court of law. So obviously somebody emailed him something, right? He's just quoting that. So secondly, I and the DHR are now present in a court of law and wait upon the arrival of the jury. And so thirdly, I did not surrender my case to act under the Federal Rules of Civil Procedure, but you do got to follow them though. Right. Fourthly, court is under the control to the law, common to the people, from within this district, common law. Right. Fifthly, the jury will judge the matters of the law, which court lays before them. Okay. Sixthly, I, a man, see no benefit as being subject to the Federal Rules of Civil Procedure, rules promulgated by a legal society in which I am not a member nor wish to be. Okay, so seventhly, I say here and will verify in open court that all herein be true. And then let's go back. So that was 10 cents. Okay, so there's 45. Okay, so 30. Whoop. I accidentally clicked on the wrong one. Sorry about that. 35. This was 10 cents. Notice, jurisdiction. So this is Karl Lentz. Okay, so obviously I cannot see that, so I'm gonna skip it. 36. So this one's free, alright. And this is an order, okay. So I'm gonna scroll to the bottom. Okay, so that's the judge. Okay. So I already saw the bottom and it said it was dismissed. So obviously this is the judge already calling it. You know, he already threw the flag and said it's over. Right. So here it is. Right. Order on June 14th, 2013. Okay. The magistrate judge followed the recommendation. Okay. Document 6. In this case, to which no timely objections have been filed. Even though he filed a whole bunch of other papers, right? So he's just taking him out on a simple technicality for Karl Lentz failing to respond to his recommendation. Right? He didn't object to the judge's recommendation, right? In document 6, and obviously we are at document 36. So Karl Lentz threw a whole bunch of freaking notices, right? But he didn't put an objection, right, to the recommendation, right? So let me read that again, right? So on June 14th, 2013, the magistrate judge filed a recommendation, document 6, in this case, to which no timely objections have been filed. Upon an independent review of the file in the case and upon consideration of the recommendation of the magistrate judge, it is the order, judgment, and decree of the court that the recommendation of the magistrate judge is adopted. This case is dismissed for a subject matter jurisdiction. Done this first day of July 13th. This is signature Mark E. Fuller, United States District Judge. And there you have it. So that's over. It's over. That's it. However, we still saw documents being filed into the case. Alright, so this is going to be the judgment right here. So there's two of them. So I'm going to go ahead and 30 cents. And I'm going to download this. Okay, so it's already downloaded. Let's click on the main one first. So this is from the judge. Final judgment. Okay, so this is the judge. Okay, in accordance with the prior proceedings, opinions, and orders of the court, it is ordered and adjudged that judgment is entered in favor of the defendant and against the plaintiff. That this action is dismissed with prejudice, right? And costs are taxed against the plaintiff. The clerk of the court is directed to enter this document on the civil docket as a final judgment pursuant to Rule 58 of the Federal Rules of Civil Procedure, done on this first day of July 2013. Okay, so let's open the $37. That's the second one. Okay, so a copy of this checklist is available at the website for the USCA 11th Circuit. Okay, so this is Civil Appeals Jurisdiction Checklist. So, appealable orders. Court of Appeals has jurisdiction conferred and strictly limited by statute. So, I guess this is just information for an appeal. Okay, so that's what that is. Okay, so that was 30 cents. Okay, let's go to 38. This is a notice. This one's 20 cents. So the case is dismissed, guys. Like, seriously, it's over. Okay, but Karl Lentz is still filing things. Okay. Notice, right? This is Karl Lentz, a man, right? So the Lentz court presents notice. Okay. So I, a man, declare a man therein claims to be counsel. Okay. It almost looks like the other one, right? That he requests to dismiss my case. Secondly, the answer opinions from a counsel wished enlightening to court are not sufficient for purposes of granting a motion to dismiss. For how does For how does court know? This is what the DHR truly believes. The court is to afford DHR the right to appear to open court before the tribunal in whist under oath or affirmation pressed her word upon the record. Thirdly, court cannot take notice of Larry Lentz, his arguments, and he nor DHR is entitled to judgment as a matter of law. Fourthly, note well the granting of the motion for summary judgment is not favorable, for normally a full trial is required, as the trial setting gives the triers of fact the opportunity to observe the parties and their evidence. Fifthly, I say here and will verify in open court that all herein be true. Okay, so and then this is proof of service to the federal court, Debbie, court clerk. 39. View document. Download. Okay, notice. This is Karl Lentz again. Notice. Party. Real. The Lentz court presents notice. Firstly, I, a man, declare my claim is against the wrongdoers, who throughout the years has referred to himself, right, as Department of Human Resources, herein DHR. Okay. Secondly, a man known as Larry Lynn claims to be counsel for Alabama Department of Human Resources. Thirdly, within my case, I claim DHR is the wrongdoer. I was just wondering what the judge and the attorneys are saying about all this. Like, they must be laughing, right? Within my case, I claim DHR is the wrongdoers. Fourthly, at the time court does not notice the interloper, a Alabama Department of Human Resources, as the same person as DHR. Fifthly, court will accept that DHR commences in other names, titles upon proof of claim. Sixthly, I say here and will verify in open court that all herein be true. Okay, so that was 10 cents. New document. Okay, he's doing the notice court again. The Lentz court presents notice. Firstly, Department of Human Resources, herein DHR wrote to me that I should pursue DHR into a court of law. Okay, I want to say that we already read this. I don't know, but we'll skip the firstly one because I know that one's already been there. But secondly, I and the DHR are now present in a court of law and wait upon the arrival of the jury. Okay. Thirdly, did not surrender my case to act under the federal rules of civil procedure. Fourthly, court is under control of the law, common to the people within the district common law. Fifthly, the jury will judge the matters of law which court lays before them. Sixthly, I, a man, see no benefit as being subject to the federal rules of civil procedure, rules promulgated by the legal society in which I am not a member of, nor wish to be. Seventhly, I say here and will verify in open court that all herein be true and correct. And that's just the end of that. Okay, so that's 10 cents. Almost done, guys. So we're at 41. This is another notice. This one's 10 cents. Notice jurisdiction. Saving to suitor. This is Karl Lentz again. Okay. So the Lentz court presents notice. Firstly, okay, you know what? Most of this work just looks like it's repetitive, right? So we're just gonna not read all that because it's just repetitive stuff. 10 cents. Okay. So I'm not going to read this, right? Because obviously this just looks repetitive. I don't know why he's filing the same things. The case is over. Okay, so this is Karl Lentz again. The Lentz court presents notice for I, and for those similarly situated. Firstly, I, a man, declare a man. Okay, that's just alright. I'm not going to read that. Thirdly, I say it is necessary and proper to protect and secure the rights of I, the people, the court, and DHR that no Wu or man, nor Alabama or ALMD employee is to interfere with my right to summon the wrongdoer, DHR, into an open court before a tribunal and require of the wrongdoer to appear under oath or affirmation and press their word upon the record as to what the DHR truly believes and what it maintains within DHR limited scope of authority, capacity in what can or cannot do to the people, in which DHR is a creation of for DHR only exists to serve as benefit of those. And I'm not gonna lie, man, I am straight up confused with, with what he just wrote. Right. Fourthly, right, I say here, and we'll verify, part that all here and be true and correct. Okay, whatever. All right, so let's just get out of that. And we're at 44. And view documents. Notice compensation. Okay, the case is over, guys. Just so y'all know. All right, ready. Okay, so this is Karl Lentz again. The Lentz court presents notice. Firstly, I, a man, declare that compensatory damages are due post haste. Secondly, the arrival of the sum for damages is based upon the belief that to charge by the rate of $1 due per every second of the wrong is fair and just. Thirdly, the amount due may appear to be extreme, but reflects the extreme of the wrong. Fourthly, to date, approximately 370 million plus seconds have passed since the commencement of the use of an instrument which prevents me from the enjoyment of my property. Fifthly, I say here and will verify in open court that all herein be true. Okay, so let's go back. And this is the last one. This is 10 cents. See. Okay, so notice, summary, judgments. This is Karl Lentz again. The Lentz court presents notice. Firstly, okay, I'm not going to read that because that's just repetitive. Secondly, the answer, arguments, opinions. The answer and arguments, opinions from a counsel which the enlightening court cannot take notice of, for his options are not sufficient for purposes of granting a motion to dismiss, nor entitled to judgment as a matter of law. He's ridiculous, honestly. Makes no sense. Thirdly, NB, the granting of a motion for summary judgment is not favorable. For the requirement of an open court, full trial is normally necessary and proper. For said trial setting gives the trier of fact the opportunity to observe the parties and their evidence. Okay, under the oath or affirmation. Fourthly, I say here and will verify in open court that all herein be true. Okay, so that was the last one. Okay, guys, so we've already gone through all of them. So I couldn't get the very first one that says jury demand, but it was already there. Okay, so obviously he lost his case, right? But there are other things here that I would like to go through, like alias. It costs $0.10. So just so that everybody can see, I want to cover his whole case. Associated cases. There are no associations for this case. Attorney. So I guess Larry Lynn was the attorney for the Alabama Department of Human Resources. Okay. Let's go back. Case file location. I don't know. I'm just gonna put submit. See what it does. Okay. This case file may be available. All right. Case summary. Okay. Deadlines, hearings. I'm just gonna put run query. See what it comes. There are no deadlines here. Okay. Docket report. I'm just gonna put run report. See what it does. Okay. So plaintiff, right? Karl Lentz. I a man. Okay. This is just everything that was filed. Okay, so let's see. On June 5th, he filed a complaint. Okay. On June 5th, 2013. Okay. And a month later, he lost his case on document 36. Right. So, wow, that was pretty harsh on him. Right. So, it doesn't look like Karl Lentz knows how to file a suit. Right. So, I guess he's debunked. So let's see. What is this? Less than 30 days, as a matter of fact, his case was dismissed. Okay, there's an option to click Karl Lentz. Okay, so this is all the stuff that he filed, right? And then, wow, the Department of Human Resources only filed one document, motion to dismiss, and wow, that's all they took, right? And he was out the game. That's crazy. Party. Okay. Deleted transactions. Run query. I'm just going through it, just so y'all can see. Status. There are no opinion status records for this case. View document. I'm just gonna put one report. Okay. So I guess that's it. Alright guys, so that was Karl Lentz's case, and I hope y'all enjoyed what I showed y'all, and y'all be sure to subscribe to my channel. Click the subscribe button, click the bell so you can get all the notifications to all my new videos, and I guess we can just call Karl Lentz not knowing how to file a federal lawsuit. And I guess all that stuff that he has out there, you might want to consider actually doing research on Karl Lentz to just know what you're getting yourself into, okay? All right, guys. Thanks for watching. Over and out.